Tomorrow.
What's up? Reporting here.
2:30. 2:30. Tomorrow. Yes. Tomorrow preliminary. All preliminary. Tomorrow it will be. So it will be listed preliminary. End of debate. Not tomorrow. Correct. Chamber cuts.
Till 1:53 to 45.
Even request made by the learner council appealing for the petitioner. List after 2 weeks. The request made by the learner council appealing for the petitioner. List after 2 weeks. Still number? Oh. Let's see in the event if leave could be granted. Yes, sir. 49, sir. At the request made by the learner council appealing for the respondent number 5. List after 2 weeks. 62 at the request made by the learner council appealing. 62. Sir. The council appealing for the petitioner has filed memo seeking withdrawal of the accordingly, the petition is discussed as 57. Your person. 57. Raghu. At the request made by the learner council appealing for the petition, list of the wait. 55, sir. Three-time update. The request made by the learner council appealing for the respondent, list after 2 weeks. What is it? Yes. Notice to? Yes, sir. 141. Okay. Office. Good. This said petition. This said petition is disposed of on 5/4/2023. And due to the clerical mistake, the entire respondents have not been arraigned in the cause title. Accordingly, registry is directed to print the remaining respondent in the cause title. It's also noticed that at paragraph 3, the respondent number 1 has been directed to consider the representation dated 13th September 2022. In this regard, I'm of view that both the respondent 1 and 2 be directed to consider this. Yes, registry is directed to reissue the corrected copy immediately. Yes. 2 weeks time is granted to comply with the officer. 2 weeks time is granted to comply with the officer.
Share number 2, my lord.
Your part? Which petition? When a counsel appearing for the petitioner submitted the copy of the copy of IA number 1 of 21 is served 1 of 21 and IA 2 of 21 is served to the counsel representing the parties. Registry is directed to verify this. No. Next. Let us listen. Yes. Statement of objection by the counsel appearing for the respondent has served copy of the statement of objection to the counsel representing the respondent. Accordingly, officer.
Petitioner. I am appearing for the petitioner.
Let us see. Does this matter in B group next? Madevaya. No representation on behalf of the petition. List after 2 weeks. IA 1 of the counsel appearing for the petitioner submitted a copy of IA 1 of 23 served on the counsels representing the respondent. Accordingly, office objection is over. You have to serve. You serve it to. Let us listen. Yes, next. We filed the memos. You complied with the payment. Sorry. The counsel appearing for the respondent has submitted that the cost of it is 3,000 as ordered by this court on 16/12/2022 is paid in favor of anything is paid to the advocate's welfare fund. Accordingly, office objection relating to the same is overruled. What about a statement of objection? Is submitted that the statement of objection is filed. That we have to matter. Is this matter for B group? Next. Yes. Finally, 1 week time is granted to comply with the office objection, failing which the petition shall be dismissed without reference to bench. Yes. But excess teacher has been made in 2017 and 18. Now, whether it could be continued. What about IA 1 of 23? Whether it's served on the other side? 2 weeks. 2 weeks time is granted to the Lana counsel appearing for the petition to comply with the officer. Petition, the counsel appearing for the petition submitted that the petitioner be permitted to withdraw the petition. Accordingly, the petition dismissed as withdrawn.
Yes.
2 weeks time is granted to comply with your office objections. Right, comply with the office objections.
My lord, serial number 11.
11, 2 weeks is timing granted.
Please.
12, 2 weeks time is granted to comply with the office objection.
Yes.
This next week. This next week. 2 weeks time is granted to take necessary steps insofar as R4 is concerned. The counsel appearing for the petitioner has submitted that office objection has been complied with. It's serving copy of IA 1 of 23 to the respondents. Accordingly, office objection is over. Next week, it will. This week, this matter, Monday, next Monday. Whatever in B group or it has to come in? It's just not in B. Next. B group. Yes. Not so. Just 2 weeks time. 2 weeks time is granted to comply with the office. Same order. Non-compliance is 2 weeks. Complaint 2 weeks. 2 weeks time is granted to comply with the office.
Serial number 17, my lord.
17, 2 weeks is granted to comply with the office objections.
We have received the objection letter, my lord.
Let us then you have to file a memo for retirement.
Kindly, a date may be kindly.
2 weeks time is granted. Yes. 18, 2 weeks time is granted. Yes, sir. Non-compliance officer. Yes. 2 weeks time is will be granted. 2 weeks time is granted to comply with the officer. Same order. Office objection. Office objection within 2 weeks. Yes, Mr. Jain.
Well,
2 weeks.
In respect of number 2, Malaj, in the connected matter, Mr. H.L. Pradeep appears, Malaj, on
Pradeep
behalf of the IDB, Malaj.
Can I direct him to take notice to serve copy?
Please, Malaj. In respect of respond number 4, Malaj, Mr. S. Saravana, Malaj, appears in the connected matter, Malaj.
Very good, I will. So, in 102.16 of 2023, Sri H.L. Pradeep Kumar accept notice for respondent number 2. Sri S. Saravana accept notice for respondent number 4.
Please.
Next week, sir?
Please, Malaj. Next week, Malaj, may have it, please.
2 weeks.
Grateful to. Next week, Malaj.
No. Malaj senior counsel 6, 2 weeks.
Malaj, a short question is involved, Malaj. Objection is filed in the connected matter, Malaj. Matter could be disposed of, Malaj.
Just 1 minute. Maybe takes to- I will say 2 weeks. List after 2 weeks.
The matter, Malaj, was posted today, Malaj.
Your request, they will. Next. Okay. NOC. List after 2, no representation, list after 2 weeks. What is this matter? Put him. Yes. Put him. What is that IE? Just 1 minute. It will take. The request made by the council appearing for the petition. List after 2 weeks. List of the request list after 2 weeks. This is a copy. Yes. Say after 2 weeks. You see EAT matter. It is EAT matter. It will be taken up for B group or final hearing next. Next week, let us. IA told accepting the cost shown in IA 2023, the application is allowed. Does this matter for the B group or final hearing next Monday? Next Monday, Leonard AG accept notice for R2 and R3. Yes, Mr. Earlier. That's why you have annexed. You already annexed. Yes. In terms of WP number 2, in terms of 22406 or 21. Third final decision. Third the council appearing for the petitioner. Sorry.
Other employees are also uploading on the
Correct.
followed the second judgment. We wish to find that observation. Internal page number 79 of the judgment. Consider the representation. The lordship is pleased
In this petition, petitioner has sought for relief against the respondent company, extending the benefits of wages, wages till the date of retirement. In terms of the memorandum of settlement dated 7/4/2006 and 30/8/2010, within bracket annexure C and E respectively, close the bracket. Pursuant to the same, the petitioners have approached the respondent company seeking redressal of their grievance with regard to pay the benefits and the arrears of revised wages till the date of retirement. However, the case of the petitioners have not been considered, and as such, the petitioners have approached the respondent company by way of representation dated have approached the respondent company as per the representations dated 23/5/2014, within bracket F series, and same has not been considered by the respondent company. That we have to matter, the respondent company being as instrumentality of the state is bound to consider the same in accordance with law. And as such, I am of the view that the respondent company shall consider the representations produced at annexure F series in accordance with law, with an outer limit of 8 weeks from the receipt of this order. It's also made clear that this court of 2021 disposed of on 23rd July 2021 and in WP number 22406 of 2021 disposed of on 12th April 2022 issued similar direction to the respondent company, and therefore the writ petition is disposed of in terms of the above. Tomorrow it will be post similar. Yes. Putting permission to file addition. Yes, sir. These grievances to pay the salary emolument, other benefits to his employment, 87 and to 1990. Then you can issue an endorsement that he is not working. Yes. It is there, annexure A. That's the annexure A. In fact, order passed by the Honorable Supreme Court is annexed.
My lord, is it serial number 25?
Yes, sir.
My lord, in this case, my lord, I am instructed by the counsel appearing that these documents what are filed are all supposedly this matter was already disposed of before the Honorable Supreme Court.
Correct.
And the time with the period of service is already mentioned by the Honorable Supreme Court, which we cannot now go beyond that situation. Fairly, I would
Correct.
admit, my lord, that the respondents, my lord, they haven't had
But
taken
now
the
we can
services.
now we can approach the CAT.
My lord,
Earlier
what has
also
happened
the
is,
matter
my
went
lord,
from the CAT to this court and to the Supreme Court.
yes, my lord, but the question, the limited scope of approaching this Honorable Court is that after the pursuant to the order of the Honorable Supreme Court, we had filed contempt proceedings.
Yes, sir.
In the contempt proceedings, they had not taken any steps to make the payments for salary. That particular period salary they have to pay. All that relief now I am asking is not for restoration of service,
Good.
not for
You can
doing
approach the
anything.
CATs because already you have approached.
Yes,
In fact, already you
but
had
for the relief,
approached the
due to this
CAT on the earlier occasion. Yes,
please,
in
my
OA
lord,
58 of 1998.
please, my lord, due to the subsequent events, please, my lord, this is the fact that
Even in
we have
there are
approached.
OAs 212 OA number 2122 of 1995. Tribunal issued direction to Petitioner to give detailed representation. Better.
All I'm saying is, as per Annexure A, the last sentence is.
You can urge all these grounds before the CH. Third, the learner counsel appearing for the parties.
I'm appearing for the counsel, my lord.
Yes, sir. Yes. Sri Suresh Lokre, Leonard Senior Counsel. Sri Suresh Lokre, There are senior counsel on behalf of Sri Shravan S. Lokre and MS Timmanna Bhatt Devate. There are counsel appearing for the respondent number 1. Sri Timmanna Bhatt Devate Lana counsel appearing for the respondent raise primary objection with regard to the maintainability of the petition on the ground that the petitioner had approached the Central Administrative Tribunal in OA number 2122 of 1995 and OA number 58 of 1998. And the orders have been challenged before the Honorable Supreme Court and same has reached minority. And therefore, he contended that the petitioner be relegated to approach the CAT for redressal of his grievance.
My grievance is only this, my lord.
Yes.
It may be observed, my lord, that the Supreme Court has observed.
Lokre appearing for the petitioner contended that the grievance of the petitioner is only with regard to the release of salary and such benefits by the respondent authorities for a period between 1/9/1987 and 17/12/1993.
Yes, ma'am.
Taking into consideration the factual aspects on record that the petitioner had already approached approached the CAT on 2 occasions, and therefore I'm of view that the writ petition is not maintainable in terms of the law declared by the Honorable Supreme Court in the case of L. Chandrakumar versus so-and-so, reported in AIR 1997 SC 1125, the writ petition is not maintainable, full stop, liberty is reserved to the petitioner to approach the CAT for redressal of disputes. Accordingly, writ petition is accordingly.
And we are permitted to urge all these grounds there.
Petitioner is permitted to urge all the grounds made in this report. Yes, sir.
Much of.
3 times. The request made by the Lana Council appearing for the respondent number 1 and 3. When do you want 2 weeks? No. Call after 2 weeks. File within 2 weeks. DA matter. After 2 weeks. Told. IA 1 of, except in the cause shown in IA 1 of 2022. Application is allowed. This matter for final hearing. It's like 2 weeks bit on date. In final hearing. Yes. Seeking extension of time. When was the order passed? When was the order passed? Huh? Heard Lana Council appearing for the parties. Heard the Lana Council for the parties on IA 2 of 2020. This court by order dated 14th March 2023 dispose of the writ petition, directing the respondent bank to take decision in the time stipulated. The counsel appearing for the respondent seeks 2 months time to take necessary action in the matter. Accepting the submission made by the Lana counsel appearing for the respondent bank is directed to consider the case of the petitioner within 2 months from today. Accordingly, application is disposed of. Yes, sir. That's Mandya B group. Sir, is this matter in the B group, preliminary hearing B group, date? Any date offer? Whatever. Dispose of matters. Is there in Gurumurti son of Siddhappa. Yes, some Gurumurti son of Siddhappa. It is not amended. No, whatever the cast title in the writ petition is there in the order. No, that is a way. Though it is technical, but it is corrected later. We have corrected it. No, not affidavit. You go to cast title in the writ petition. How can we after dispose? That makes a lot of difference. That makes a lot of. While review, I will review. I will do in review. All. Sir, what? That I made. It makes a lot of. So we will look into the cast title in the writ petition. What is there in the cast title in the writ petition will be incorrect.
Already, just to get
If file review relating to the same, it will be considered. It cannot be done now because it's already that we have made. Again, you say that the entire thing has to be changed. That cannot be done now because it's already. I think we have made. I think some computerized. It has to be changed. It cannot be changed now. So I can change. You can change. Not computer. If you want to order sheet, correct order sheet, you have to file it. I can change. No problem. You can also change, but computer cannot change. Because the respondent name has to be rectified. There, sir, but so the respondent, it makes a lot of difference.
sir, it should be written.
Not, you go to the cast title in the writ petition.
There is a mistake on all sides.
No, no, from your side, no, not from court side. Because you say that you are working in first grade college at Chitradurga. In the writ petition, cast title, you say that working in Bangalore University, Jnana Bharat. I will rectify, you file an application. Application you file. There it will be done. No? Huh? Just I will inquire. Because it's already, we have, if it is possible, I will do that. I will get the instruction from the, because it already we have, no, now the computerized. Chamber, I will do that in the event if permissible under law. Yes. The 2 weeks, B group letter. Is this matter in the B group after 2 weeks? Next. Interim order granted earlier extended till next. No, why vacating interim order? Take up next week in B group. No, it will be taken up. Very long. Nothing will happen another 7 days. There's this matter in the B group next. Tomorrow some other matters. Next week on this. Notice. No. Issue emergent. And the council application is also permitted to make notice on the panel. Response. I think had appeared. Page 18. Page 18 of your report. Had appeared. Very same matter. Same person. Same. Not before ESI. Not before ESI. Page 18. This had appeared for against you. This is the same matter. Yes. What is the rule? What is the rule provides for belated applications? Correct. Correct. Issue that's it. Then a DG accept notice for respondent number 1 to 3, 1 to 4, Allah? 1 to 4. Get instruction. Yes. Let's consider everything. Who appears in Nagaya? Third. Final order. Yes. In this, yes, will be done. This repetition. Please sit down. Please sit down. The grievance of the petitioner. First result, Leonard AG accept notice. Leonard AG accept notice for respond number 1. Sri Nagaya accept notice for respond number 2. It is the grievance of the petitioner that petitioner has made a claim for accommodating the petitioner as a Kannada language teacher or overall any post held by him in the respondent number 2 society. In this regard, petitioner has approached the respondent number 2 by representation dated 13/10/2022 and 18/10/2022 within bracket annexure F and G, and same has not been considered by the respondent number 2. That we have to match. Respondent number 2 is directed to consider the representations referred to above in accordance with law, in outer limit of 8 months, in outer limit of 8 weeks from the receipt of this. Accordingly, repetition is discussed. Yes. Notice. Notice. That AG accept notice for respondent number 1 to 5, issue emergent notice to 6. Notice. Notice. Let the notice shall be. Because we don't know work order is issued or not. Because it was issued in January. That's correct. January the work order is. Let us will see. Now it cannot be. Leonard AG accept notice for respond number 1 and 2. Issue emergent notice to R3. That we will see. Where is that? Who is R4? Where is the impleading applicant's address? Which? Yes. Where is that? Where is it? Impleading applicant address. After third verse. Where is the address of the impleading applicant? In the event I have to issue notice, his address should be there. Which ISR? Yeah. No? It's not there. I would say issue notice. Yeah. You get it. Otherwise, it will be. Issue Leonard AG accept notice for 1 and 2. Issue emergent notice to respond by 3 and the impeding respondent number. Yes. Get this. Yeah. Let the notice shall go. Let the notice shall go. Next 2 weeks. 6. Yes. Budget. Issue emergent notice. Petitioner is permitted to serve copy of the petition to the panel counsel representing the respondent corporation. Or at the bottom, second one bed. BL Sanjeev accept notice for respondent corporation. Lana counsel appearing for the petition is permitted to serve copy of the petition to the Lana counsel representing the respondent corporation. Yes, sir. How it can be mandamus will be issued. Yes, sir. How can your prayer will be considered? Sir? For that, you have to approach the authority. Where is that? Not legal notice. You have to approach them. Let the notice shall go. Issue emergent notice to the respondents. Tag along with WP number. Yes. Yes, Mr. Arame.
42
Yes.
appear for petitioner, my lords. My lords, so he was the storekeeper, my lords, who underwent, my lords, after 17 years of, my lords, rigorous, my lords, department inquiry. Ultimately,
Right.
there was judgment in his favor, my lords. He asked for his nomination, my lords, change of nomination.
Yes.
He has 2 wives. Initially, they asked for no NOC from the first
First
wife.
consider
My lords.
respondent number 1 has to consider.
Please, my lords.
BL Sanjeev accept notice. BL Sanjeev accept notice for respondents. The grievance of the petitioner that the petitioner has made a representation dated 11/8/2021 in bracket annexure A seeking acceptance of her nomination in the family pension, and same has not been considered by the respondent corporation. That view of the matter, I'm of view that the respondent number 1 is directed to consider the representation dated 11/8. Who has to consider actually?
The respondent number 2 has to consider now, my lords.
Therefore, the respondent number 2 is directed to consider the representation dated 11/8/2021 in accordance with law in the outer limit of 8 weeks from the receipt of this order.
Much obliged.
Yes.
Serial number 43.
Yes, sir. Yes. Notice, notice. Emergent notice. So emergent notice. Let the emergent notice shall go. 21. 21, sir. 21 ಅಲ್ಲ? Page 221. Next. Yes. APC are concluded, but no decision would be taken until points are direct not to give effect to any DPC until the next setup. The matter is right? Identical matter if it is told. Then a DG accept notice for respond number 1 and 2. Issue emergent notice 3 to 6, 3 to 8, 3 to 8. It is submitted by Sri Lana Senior Counsel Sri MS Bhagwat that an identical matter in WP number 1575 of 2023 within bracket annexure K. This court has granted an interim order and same has to be adopted in the present repetition. The said submission has been opposed by learned additional government advocate. Having taken note of the grounds urged in the writ petition and the observation made by this court in WP number 1575 of 2023, I'm of the view that the respondents are directed not to give effect to any DPC proceedings till next set of hearing. Same order. Next, let it be there. Yes. Yes. The similar petition is granted is not correct. To deny it, very same relief to the other person. Yes. Yes, madam, what is this? Take 2 minutes. So this is in furtherance of the earlier order. Just yes.
There are people who are eligible.
Yes.
But promotions cannot be affected because of their being what is entry, what is the bracket or final or
Correct.
the other contingency is where there are no persons eligible for promotion. Some in charge arrangement.
Yes.
The first contingency, what regulation 35 provides is that if any in charge arrangement is made, then the period of the in charge arrangement will be computed for the purpose of determining the seniority of that cadre on an eventual promotion of that person. So if the person is placed as in charge,
That's a regulation.
was 816.
16. Yes.
Why is no eligible for such promotion cannot be promoted to such responsibility? Why should be based independent charges of duties?
What was not given to him earlier?
Now, what you are not they have held, will not be eligible to them. We can be indirectly claimed under regulation 25.
Such an employee is subsequently held eligible to higher pay from the date on which he was placed in the duty. It is permissible to change the in-charge tenure officials from retrospective effect.
Then, regulation 25 permits. This is a section 110. So, what is other stated 27 March 2023.
Yes.
28th of March 2023. Second is, they refer to Lega, page annexure C, page 110.
27th order.
87 is your lordship's order. 28 order. There is no bill. I'm going to make it something. What he said, we are going to implement the orders of your lords. Maybe 2 months time. This cannot happen because this only an in-charge arrangement without any longer being
In fact, this will run contrary to the regulation.
No promotions. In-charge arrangement.
Yes. There will be a very well. There will be a stay for children. I think Ms. Shirish Krishna accept notice for respondent number 1 and 2. Your first 3. Srimati Ansuya accept notice for respondent number 3. Issue emergent notice to respondent number 4. Having heard Telangana senior counsel so and so appearing on behalf of Madam so and so, that wherein it is contended that the impugned order dated 18 May 2023 has been passed by the respondent corporation pursuant to order dated 27th March 2023 in WP number 12567 of 2020, and also taking into consideration the regulation 35 of the which is that regulation, entire regulation. AIT, what is it? There's appointment by transfer. Taking into consideration the regulation 35 that this memo here, which is that piece 6 months. And also with regard to the say regulation 35 of the respondent corporation, comma, I must review that there will be a stay of the official memorandum dated 28/3/2023 within bracket annexure C and OM dated 28/3/2023 within bracket annexure D to the requisition till next set of year. You file objection letter. It will be no. Runs contrary to it. I read it actually. I read it in detail. No, there will be a interim order. See this, sir, the corporation cannot take that this court is just close this sentence. That one sentence is sufficient. That one sentence is sufficient. They must know that High Court is working in Karnataka. It's not correct. In the event if the order is challenged and if it is set aside, then it is a different situation. It's a different. Next. They cannot circumvent. They cannot circumvent. Then I will say issue notice to 3 and 4. That's right. Next. Then I will issue notice letter. Insofar as ordering notice, taking notice. Next 44 also. 44 also same order may be passed. Sir, the corporation cannot act like that. Indeed. Yes, that is better. That is better. So, Series Krishna accept notice for the respondent number 1 and 2. Issue emergent notice to 3 and 4. That does issue emergent notice 3 and 4 in both. Yes. Ganeshan. Mandamus. Which representation? Annexure K has to be considered. Sainika Kalyana ಮತ್ತು Punarvati. You pass an order already. Annexure M. Field Marshal Karyappa Bhavana. Final order. Will direct it, dispose. Heard since 2012 for this. The petition is pending. Just for this. Heard the learner council appealing for the grievance of the petitioner that the petitioner has approached the respondent authority seeking sanction and grant financial assistance in terms of the Ministry of Defense letter dated 12/1/2011 and same has not been considered by the respondent number 1. In that way of the matter, taking into consideration the factual aspects on record that the petitioner is an ex-serviceman and the writ petition is of the year 2012. Petitioner is permitted to make one more representation to the respondents at the earliest with an outer limit of 4 weeks from the receipt of this order. And if such a representation has been made, the respondent shall consider the same within 8 weeks from the receipt of such a representation. Accordingly, writ petition is dismissed. Yes. The request made by the learner council appealing for the petition. 2 weeks, just after 2 weeks. Respond. What is this? What is the matter, sir? Huh? EAT order is. What ground tribunal rejected? Not a permit. Yes. The temporary employee dismissed, removed, or removed. Said provision is not applicable. Oh, I think what we have said in earlier. The opportunity. Is a temporary employee. No representation has been made on behalf of the petitioner. And the council appealing for the respondents are present in order to provide an opportunity to the petitioner. This matter day after tomorrow at 2:30. Day after tomorrow, 2:30. Yes, sir. Just 1 minute. Yes, sir. Ah. 1 minute. Weeks time to produce relevant documents to establish that the petitioners herein have been appointed on contractual basis or through outsourcing. Yes. Yes. According to you, they are outsourced. Prior to that, 30. Someone has to produce. The only person, someone has to produce. Yeah, but yes. You are also ready? You can argue. Who are the petitions? What is the material to shoot? 1995, that the first petition. What is the material at least?
I have put the records. With respect of the first petition, page 45.
45. Yes.
Instead of the receipt, the payment for made to the customer.
Yes. So this is of 1/2/1999. Yes, sir. Yes. Connection? Yes. Page, sir, page. Ah, yes. Which, say number 6. Usha. Usha Pass, Karnataka State Corporation. Yes. September 1995. Why don't you cross check along with this? Cross check. May-
Page 76.
76. Sir. Mehboob Ismail. As a watchman. Yes.
Page 79.
D2. Yes, sir.
H, ETC.
86, sir.
So, why 1996?
Yes, manpower required. Yes.
We are utilizing the service of 8% as against 6.5.
Whether the petitioners are one among the 8 persons. Of the letter 1996. You have the material. Reconsider at least. Reconsider in the light of this your own letter. You cannot raise it because you don't have any records. You submitted, you don't have any records. How can you say that no relationship? But according to the annexure F, if you say it is in your letterhead, that is by the DGM, approach letter addressed to the DGM, saying that 8 persons as against the shortfall of 90. Shortfall means as against the sanctioned posts.
What's my line is in your page
104. 104. Yes. That against authorized posts of employees. Yes. Yes. Thirty vacancy.
What had happened was subsequently all of them. So when it was them have been appointed, you know what had happened? Yes.
What is impugned order annexure B say that? Impugned order, just endorsement of contractual level.
They are not possible.
You say that sanctioned vacant post and you are working in daily wages uninterrupted for more than 10 years is false and not correct. That's what you said. But if you look at your own letters, they worked since 1996. Reconsider. I will set aside and let they will reconsider. In the light of the, even if we take for an example, the letter dated D2 and 5th September 1996 annexure. It is their letter only. The only thing is their shortfall of vacancy as well as files. Yes. Yet since 2019 that they are not done. Why you have to say? They may do so. No, till consideration of your case, let they cannot publicize. Insofar as these four posts.
Because other two, what they have, is to put that. Fortunately, these things, the employees are.
From annexure F, it's your letter to the DGM. You are saying that there is 8 persons as against a shortfall of 19. You reconsider it. One seven, sir. 117. Yet 30th November 2004. Proceedings of the meeting. Annexure A5 ಅಲ್ಲ? Annexure? Annexure? 1 minute. Yes, sir. Reconsider. 95 that they are working. And we get 10 software engineers in a road. Not even to get a plumber is not that much easy. Yes, sir. Plumber, good mason, not that much easy. Carpenter, not that much easy to get. You can get 10 software engineer in a street, in a one street, you will get it. Told you. Please should answer. In this writ petition, petitioners have challenged the endorsement dated 2/1/2019 in bracket annexure B issued by the respondent number 1, rejecting the claim made by the petitioner for regularization. The relevant facts for adjudication of this petition are that the petitioners are claimed to be appointed by the respondent corporation all of them are D group. As a D group, I leave it. As a D group employees. And the case of the petitions have not been considered by the respondent corporation for regularization, despite the fact that the petitions hearing are rendering service in the respondent corporation as attenders / peon / machine operators in the office of the respondent corporation since 1995. It is further contended by the petitioners that these petitioners are working as against the sanctioned post, and therefore placing reliance on the letter dated 5/9/1996 within bracket annexure F, the petitioners have contended that the petitioners have been permitted to work on daily wages in the respondent corporation, and despite the fact that they have been continued to work since 1995, and the respondent corporation is availing their services. However, the case of the petitioners have not been considered by the respondent corporation for regularization of their services. Accordingly, the petitioners have approached the respondent corporation seeking regularization, and same came to be rejected by the respondent corporation as per impugned endorsement dated 2/1/2019 within bracket annexure B, and being dissatisfied with the same, petitioners have presented this report. I heard Sri S.B. Mukannappa Lana counsel appearing for the petition, and senior Bipin Negde Lana counsel appearing for the respondent corporation. Sri S.B. Mukannappa Lana counsel appearing for the petitioner invited the attention of the court to the various documents produced to substantiate the fact that the petitioners have been working in the respondent corporation since 1990. Sri S.B. Mukannappa emphasized on the letter dated 5th September 1996 within bracket annexure F, and contended that the perusal of on perusal of the said document, the respondent corporation itself has admitted that the 8 persons have been appointed as against the shortfall of 19 persons, and the petitioners herein are one among the 8 persons rendering services with the respondent corporation. And the said fact would demonstrates the fact that the petitioners were working with the respondent corporation since 1995 as against the sanctioned post. And accordingly, he submitted that the reasons assigned by the respondent corporation as per annexure B to the petition is honest and without considering the documents referred to in the writ petition. Annexure? Yes. He further contended, that as per the proceedings of the respondent corporation board meeting dated 19th June 2007, and argued that the respondent corporation in its board meeting has authorized, as noted, that there are 1,259 employees or on the rule of the respondent corporation, leaving 27 numbers of vacancies, under which 30 vacancies where 30% are working and as class C. And also he argued that the board has resolved to take decision in the matter, taking into consideration the services rendered by these petitioners, basically in the cadre of attenders. Accordingly, he sought for interference of this. Per contrast, Sri Bipin Negade Lana Council appealing for the respondent corporation reiterates the government's made in the statement of objections and particularly emphasize that the petitioners herein are working through the security agencies, particularly outsourcing from the Bangalore Security Services. And in this regard, he refers to the various payments made to the said security service agency. Accordingly, denied the submission made by the Lana Council appealing for the petitioner that the petitioners are working in the sanctioned post. Yes, sir. He also contended that there is no relationship between the petitioners and the respondent corporation as employer and employee, and therefore, considering the case of the petitioner for regularization does not arise. In the light of the submission made by the Lana Council appealing for the part, on careful examination of the writ papers would indicate, particularly with regard to the bills dated 1/2/1999 and 1/2/99 produced at Annexure A to the petition, and subsequent bills would indicate that the payments have been made to the petitioners by the respondent corporation. It's also forthcoming from the statement of daily wage employees in the respondent corporation as per Annexure B, which would indicate that the petitioners are working from September 1995. September 1995. Taking into consideration the factual aspects on record that the petitioners herein are working with the respondent corporation, and also the said aspect has been considered by the respondent corporation in a letter addressed by the Assistant General Manager to the DGM within bracket administration, KSFC head office Bangalore, dated 5th September 1996, wherein it is stated that the respondent corporation has utilized the services of 8 persons as against shortfall of 19 persons. And this would indicate that the petitioners herein have been working as against the sanction. Taking into consideration the discussion made during the board meeting on 19th June 2007, dated within bracket Annexure P, wherein the board has resolved to authorize the chairman and managing director to fill up the identified vacant post by following the cadre and recruitment rules, by providing relaxation of age in respect of the people with experience, which would include the case of the petitioners in the respective branch in the respondent corporation. I'm of view that the reasons assigned by the respondent corporation, rejecting the claim made by the petitioner as per endorsement dated 2/1/2019 within bracket Annexure B, is contrary to the records and the reasons assigned by the respondent corporation that the petitioners hearing are working as Group D employees, not against the sanctioned post, and not more than 10 years is not correct. Accordingly, I am of view that the endorsement lacks application of mind by the respondent corporation. Accordingly, the endorsement dated 2/1/2019 is liable to be set aside, and the matter is remitted to the respondent corporation to consider the case of the petitioners in accordance with law in the light of the judgment of the Honorable Apex Court in the case of State of Karnataka versus Uma Devi, quoted in 2006, Volume 4, 1, SCC 1, and further orders passed by the Honorable Supreme Court to consider the case of the employees, those who have worked for more than 10 years in the respective establishment, as against the sanction post. That of the matter, I pass the following order. Writ petition is allowed to endorsement dated 2/1/2019, passed by the respondent number 1, in bracket annexure V is set aside, and the matter is remitted to the respondent number 1 to consider the case of the petition for regularization in the light of the observation made. It's also made clear that till the consideration of the case of the petitioners by the respondent corporation, the respondent corporation shall not disturb the petitioners from their establishment. Yes, sir. The respondent number 1 shall consider the case of the petition for regularization in the light of its observation made above in a period of 3 months, in period of 3 months from the receipt of this. Ganesh. Yes. File objections. Opportunity. At the request made by the Lana Council appearing for the respondent, to file statement of objection. List after 2 weeks. List after 3 weeks. List after 3 weeks. Yes. Objection file like this.
I appear for respondent number 1 in this case, Lord, 53.
Number 1, sir.
Yes.
Yes.
Lord,
Whether objections is filed, sir.
Objections are not filed, Lord, but the matter is covered by judgment of this honorable court, Lord, of division bench. My learned friend himself had appeared in that matter, Lord.
Just I will.
Against him. Your Lordship may take it up at 2:30, my Lord. I'll produce the judgment. Your Lordship may close this matter.
2:30.
Yes, please.
2:30 can I take up or any other day? Can I take it up 2:30 or any other day? Any other day.
Next week, Your Lordship may take it up, my Lord. File formal objections also. And then
what the Learned Senior Counsel said, the prayer made the division bench of this court in identical matter insofar as the pension regulations have taken a view. That's why. Yes. Yes. So whether the division bench order related to by the division bench is related to regulation 22, sir?
My Lord, it also covers regulation 22. In fact, my Lord, my learned friend who appears for the petitioner had in Muniraju matter, my Lord, had also
I think file a formal reply better than.
Yes, my Lord, I will do that. Next week, Your Lordship may take.
At the request made by the Learned Council appearing for the respondent bank to file statement of objection. 2 weeks, it may be taken immediate after 2. Just after 2. Better. Yes, Mr. Suprema. The request made by the Lana Council appearing for the respondent corporation to file the statement of objection. 21, list after 3 weeks, list after 3 weeks. Fifty-five, 56. 21 matter. At the request made by the Lena Council, I think, for the respondent to file statement of objection. Finally, 3 weeks time is granted to file the same. In the absence of the same, petition will be considered for disposal. Yes, Mr. 1 minute. Yes, they are not filed. One minute. What you were challenge? Writ of such a setting aside the order dated 21 annexure or mandamus to for promotion to the prosecutor. Assistant executive engineer. 27. State government to take its stand clear as regards to the instruction to be issued by the appropriate government relating to reservation and a promotion in terms of first provide. Yes. 27/7/22. This court has directed the government to take instructions with regard to the applicability of the reservation so far as promotion concerned. Promotion is. So do one thing, file better reply. Yes, sir. File reply. Let they will file reply by way of affidavit. Yes. BWSS please concern. The board regulation. What it says? There is a Honorable Supreme Court has stated in one of the judgments. I think state government has taken a decision. 4% or 4%. C and group C and D. Then only thing is it has to be extended to the undertakings, state undertakings. Absolutely, it's an instrumentality of states. Once it is applicable to the state government, same has to be extended. And this is under 2016 Act and section 34. Section 34. Get instruction. When do you get it? So, this court by order dated 27/7/2022 directed the government to take appropriate decision in the matter relating to providing reservation to the class of persons comes under within the purview of the rights of persons with disabilities Act 2016. When AGA seeks a week's accommodation in the matter, accordingly, respondent government is permitted to file a reply by 1 week time by 30th. This matter on? Next 2 days. First, second letter. Second, list on second. Here, Ganesh. Yes, sir. Pass on one bit. Pass over. Satish. Answer. When you are going to retire? 31. What then? Other 8. Then 8 is. I will say submitted after going through the same zones. In this annexure G. 1 minute. Page. No, I will caution so far as the petition is concerned. Any of this is due retire. Heard the please don't. Heard the Lana council appealing for the parties. In this writ petition, petitioner is seeking quashing the order dated 1/7/2022 passed by the first respondent within bracket annexure G insofar as it relates to the petitioner and the third respondent. Having heard the Lana council appealing for the parties, that it is not disputed by the Lana council representing the parties that the petitioner is retaining superannuation on 31/5/2023, and that way of the matter, in the ends of justice, and taking into account the grounds urged in the writ petition, I am of the view that the writ petition deserves to be allowed. Accordingly, the order dated 1/7/2022 in bracket annexure G, insofar as the petitioner and third respondent is set aside. Accordingly, the writ petition is approved. Another 8 days, so transfer will be done. Yes, sir. Yes, sir. The 7 days. He is anyways retiring. Happily retire. DP Vijay. Yes. ಏನ್ matters? ಏನ್ matter? G is challenge.
Lord, serial number 61, my lords.
Yes, Mr. Vijay Kumar. Mr. Mukkanappa seeks 2 weeks time in this matter.
My lord, the matter relates to, my lord, selection and appointment to the post of assistant professor in agriculture university, my lord. So the
big grant
and respondent who is appointed to the said post, my lord, who hails from Tamil
file a
Nadu.
statement of objection within 2 weeks.
Already, my lords, there is some urgency, my lords. So the migrated person has occupied the post.
I will grant. I will give date. Let us.
The Honorable Supreme Court has already observed in that view, my lord.
Made by the Lana Council representing the respondent number 1. Oh, it's Isaac Elanka.
Yes, my lord.
That's
I request my lords to kindly fix a date.
finally, this time is granted. File statement of objections. 3rd week only. Is this matter on 13th? Sir?
Please, my lord.
13th.
Oblige me.
Yes. disposed. What is this matter? Permit the petition continue the guest lecture. 23, 24. Their petition ಮಾಡಿದ್ರೆ ಹಾಗೆ ಮಾಡೋಣ for the academic year. ಇದೇ ಮೇಡಮ್ ಆರ್ಡರ್ ಇದೆ ಸೇಮ್ any academic year is completed. Will grant relief. Maybe he feel that he has succeeded in the matter. So third, the Lana counsel appearing for the parties. The grievance of the petitioner that the petitioner is working as guest lecturer in commerce subject in the respondent number 3 college, and thereafter she has been continued in the respondent number 3 college. Taking into consideration the averments made in the petition, I am of view that the relief sought for by the petitioner in the petition is covered by an order dated 23rd of February 2023 in WP number 101238 of 2023. In terms of the order passed in the above writ petition, the present writ petition is disposed of with a direction to the respondent institution to continue the petitioner as a guest lecturer till completion of the present academic year. Present academic year to 2022-2020. Accordingly, writ petition is disposed. That is their religion. Yes. Accordingly, writ petition is disposed. Yes, Mr. Vijay.
Lord, the matter, the petitioner, Lord, who is seeking for promotion and retrospective promotion, Lord,
From
his juniors are promoted.
From revenue assessor, retrospective from the date of.
Yes, ma'am. His juniors are promoted on 28/5/2020.
Only thing is, annexure prayer 2 has to be considered.
Yes, ma'am. Annexure J, Lords, may kindly be seen, Lord.
Let you consider.
Please, my Lord. There will be a specific direction, my Lord, since the proceedings, my Lord, so this honorable court has already quashed the proceedings, my Lord. In that view, my Lord, so my promotion has been considered. But prospectively, they have considered, my Lord, so that
you will consider annexure L in a time bound.
Please, my Lord.
Yes. Third, the Lana counsel appearing for the parties. It is so in this writ petition, the grievance of the petitioner that the respondent corporation has not considered the case of the petitioner for promotion to the cadre of revenue assessor retrospectively from the date of his juniors were promoted on 28/5/2020 within bracket annexure A, and accordingly the petitioner has approached the respondent corporation by representation dated 12/8/2022 within bracket annexure L. Having taken note of the submission made by the Lana counsel appearing for the parties, and it is the grievance of the petitioner that the respondent corporation has committed grievance, has committed error in not considering the case of the petitioner for revenue assessor retrospectively from the persons those who have promoted on
28 by 20.
20, I'm of view that who has to consider as a mixed up.
Lord,
So the second respondent hearing
second
Yes.
response.
consider the representation dated 12/8/2022 in bracket annexure L with an outer limit of 8 weeks from the receipt of this. Yes, sir. Oh, yeah. Which court will say do it illegal and that to corporation, BDA.
Lords, the criminal proceedings, Lords, already this honorable court has quashed the proceedings, Lord. And I'm acquitted.
And result of the same
2010
will
itself.
be to the petitioner at the earliest. It's also made clear that this court has not expressed any opinion on the merits of the cases. Yes.
I'm obliged.
Petition is disposed. Yes. 65. Two, sir. But what is the petition? No, I will grant you time. Just I will see the prayer. Whether it requires or not, that's all. Annexure A is challenged. Let you will file. Challenging the OM dated 7th. At the request made by the Lana Council, appearing for the respondent number 2 to file statement of objection. List after 3 weeks. 3 weeks put on date. Yes. Request time, sir. Yes. Yes, sir. Yes. Motion what? First respondent to promote the petition to the post of assistant revenue officer. Terms of DPC minutes held on 7th. Yep. Why? On what ground? Exonerate. Are pending against you. I think some orders we have passed. Sealed cover, opening sealed cover and petition. Previous year. Other pass module. Opening of the sealed cover in the event if they have been observed. I think we have passed. I think following the order passed by SG Pandit sir. Consider taking into consideration the law declared by the Honorable Supreme Court. And according to him, he has been exonerated. Taking into consideration the law declared by the Honorable Supreme Court. Please, guys. Lecture H. 3. They are law-abiding citizens. We have to respect always. Where may be. Not all. Please, Raj. In this petition, petitioner has sought for direction to the respondent corporation to consider the case of the petitioner for promotion to the post of assistant revenue officer in terms of the DPC meeting held on 26/9/2022 and 11/10/2022 2012, sir. Is it 11/10/2012? 11/10/2022. Page number 27 and 11/10/2022 within bracket annexure F by opening the sealed cover and to extend all the benefits accrued to the petitioner. It is the case of the petitioner that the petitioner, as petitioner was as joined the respondent corporation during 1996 as Group D, and thereafter he has been promoted as a revenue inspector in the year 2004, and thereafter as first grade revenue inspector, and further promoted as assessor in the year 2015 in East Zone of the respondent corporation. It is further stated in the petition that a charge sheet dated 1/2/2021 was issued against the petitioner by the Anti-Corruption Bureau, and a criminal case was launched against the petitioner in crime number 1 of 2018. An inquiry was conducted against the petitioner, and the petitioner has been exonerated in the charges leveled against him by the respondent corporation, as per inquiry report produced at Annexure C to the report. The grievance of the petitioner that, though the criminal case has reached finality, though the inquiry has reached finality, exonerating the petitioner from the charges leveled against the petitioner, and the case of the petitioner has been considered for promotion by the respondent corporation in its DPC meeting held on 26/9/2022 and 11/10/2022. However, due to the pendency of the criminal case, the respondent corporation has not considered the case of the petition, as the case of the petition has been kept in the sealed cover for consideration due to the pendency of the criminal case pending consideration against the petitioner in crime number 1 of 2008. Hence, this petition is filed. I heard Sri Subramania Bhatt, M. Lena counsel appearing for the petitioner, and Sri Subramania M.A. for the respondent corporation. Sri Subramania Bhatt, M. Lena counsel appearing for the petition contended that the petitioner has been exonerated in the departmental inquiry conducted by the respondent corporation as per the inquiry report dated 4/12/2021. And the charge sheet has not been filed against the petitioner in crime number 1 of 2018. And therefore, the case of the petitioner has to be considered for promotion by opening the sealed cover, accordingly sought for interference of this. Per contra, Sri Subramani Lena counsel appearing for the respondent corporation justify the action of the respondent corporation, stating that, as the criminal case has been launched against the petitioner and same is pending consideration before a competent court in crime number 1 of 2018. And accordingly, Sri Subramani submitted that interference at this stage with regard to providing promotion to the petitioner does not arise at all. The light of the submission made by the Lana Council appearing for the parties, it is not in dispute that they have been exonerated in the inquiry conducted by the respondent corporation as per inquiry report produced at Annexure C to be written. The only grievance for not considering the case of the petitioner for promotion is on account of the pendency of the crime number 1 of 2018 against the petitioner. It is forthcoming from the writ papers that the charge sheet has not been filed in crime number 1 of 2018, and therefore I am of the view that, in terms of the law declared by the Honorable Supreme Court in the case of Union of India and others versus Anil Kumar Sarkar, reported in 2013 for SCC 161, and following the declaration of law made by the Apex Court in the Apex Court. Now, to you that the sealed cover kept by the of the opinion that the respondent corporation be directed to open the sealed cover and provide promotion to the petitioners in accordance with law, taking into consideration the law declared by the Apex Court in the aforementioned petition. The respondent corporation is directed to complete the entire proceedings, entire exercise in outer limit of 3 months from the receipt of this order. The result, writ petition is followed. Judgment it goes. Yes. 2015 matters. What is this DNS? Yes. Only relating to the gratuity.
The order. The duty amount. Who have legality?
I am. What is it? What is the charge? Yes. Charge sheet has the page. Charge memo at the page.
The election in
23. 1 minute. Statement given, yes. 2014. Not a good year for you. Not a good opening year for you. Not a good opening year for you. 1/1/2014. 73 proceedings of the estate. What is annexure F, sir? Imputation of charges.
Charges, the number of charges. They are not specific.
Yes. Yes.
Based on the that draft memo.
Yes.
So that's why we have a lot. The particular has not even.
Yes. Where is the inquiry reports? 90. Proceedings of inquiry reports. One 40. So annexure L is the inquiry proceedings. Yes. 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 Rule 70. Parasis. The procedure for the inquiring authority may, after the officer generally question him on the circumstances appearing against. Yes, sir.
But after goes on the case, Rule 70 is what?
After
Goes on the case. It is not particular to the rule. Why must it be? Just if the officer applying has not declared the ground, then the consider.
yes.
Decide we are not doing the job. By getting just
In the case, then it has to be remitted. 7. 58. 58 plus.
last day. After evidence also that
66.
Literally, not that.
But if the order impugned is set aside, only de novo inquiry has to. No, 66 is not a old age.
There will be a lecture week, so far.
20?
One is this,
Yes.
that one is the lecture week.
Show cause notice. By gratuity shall not be required. According to at least annexure, we shall go according to you. Here the other side. Not there. Say further reading. Who appears? TRK Prasadan. No, on the opportunity. So, her CMS Bhagwat, senior counsel appearing on behalf of Sri Satish K for the petitioner. No representation on behalf of the respondent. In order to provide an opportunity to the respondent, does this matter? 2:31. Next week only. Next Monday today. Next Monday at 2:30 for further reading. It will be concluded. No. Then let us listen. Password ready. Okay. 68 matters. Madhyana ಇದೆ ಅಷ್ಟೇ. Yes. Minimum 15 has to be disposed of in it. That is my. Only duty for me. Okay. The petition is allowed. Entire selection process adopted by the respondents for a post of assistant professor in political science subject as per Annex D is set aside and the matter is remitted to the respondent number 4 institution to conclude the entire selection process within outer limit of 3 months from today by considering the applications already made by such candidates pursuant to the notification dated 22/2/2019 within bracket Annex D in accordance with the observation made above. It is made clear that the respondent number 3 university shall appoint nominees to the selection committee within outer limit of 1 month from today and communicate the same to the respondent institution to complete the entire exercise as stated. That's request. End of the list. Yes. 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 Permanently. 90. Yes. 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 Sir, only special consideration subject to reasons. Now it is one autonomous to another. Mysuru, Bengaluru, Arjun. Correct. Hubli. Point number 4, the last. एक गुण को और तो पॉलिसी 30 गुण की लिस्ट ये एक के वर्तमान में it is between see even the college the college very now he has transferred to the Bangalore A group. Within 2 years. Within 2 years. Correct. Why there are four? Why there are four petitions? Hold. Leonard AGA accept notice for respondent number 1 and 2. Issue emergent notice to 3 and 4. In the meanwhile, stay of the operation of the notification dated 18/5/2023 within bracket annexure A passed by the first respondent till next date of hearing. Yes. And deliver. 59, yes. Ready, Allah? People ready? Both of you are ready. Part-time employee. Yes. Yes. Forty. 48, sir. Yes.
Working hours, 6 months per day. Reported.
Yes. Yes. What is this required? No, what is this required except our annexure A?
Has been appointed for 6 hours per day. So the settlement shall be.
Annexure D. Yes.
Part-time employees. Wages are consolidated amount of 3 hours at bank's destination with the minimum of 50. More than 3 hours at residence 6 hours. Minimum of 1,050.
Yes.
Here, distance 6 hours. Petitioner is appointed for 6 hours. So he is a regular. He is a regular. He has been of the 6 hours. Paid wages, consolidated amount. Settlement.
Yes. Next.
Deposition, he was also issued the charge sheet. As per the deposition.
Annexure F is the charge sheet. What is the charge?
That will be for some. Employees. It is executed with the provider.
Yes.
Reason must be given.
Page number? Yes. Sir.
W1. He was PTA on consolidated basis and he was extended. Also use
Yes.
For the student, last year. Degree.
Correct. Yes. Sir.
She is issued a deputy government.
Yes.
He has a It is.
Who- Maybe two. See, what is his designation? Who is the appointing authority? Who is the appointing authority? Let us go to annexure. Annexure. Senior manager owns. So according to DGM has no authority.
Yeah. Please clear one of the chief. There is a settlement.
Yes.
Page number 16.
Yes. Sums of settlement is 59. Yes.
So these are page number.
Yes.
Any notice order charge. Here is also. Proceedings also.
Yes.
Sign.
In which language is signed? In which language is signed?
Here sign in English.
That's enough. 77 Supreme Court. No, 77 Supreme Court. You need not understand. No, it's a very settled principle. No, settled principle is the person one who sign in a particular language is known to him. That's what the Supreme Court said.
Just write.
I know. I know. Need not be. The language in which a candidate is signed is must known to the contents of. Yes. Yes. Yes.
1610. Yes, Patel, mother of Mirabai Patel, operator of Shakti Enterprises.
Yes.
He gives settled musicians statement and getting for 1 lakh rupees. And six, 7 cases salary. And he gives the
Yes.
yeah, because
Yes.
money content he did not so he did not She was working. So she went there. She went there and gave my information to other staff.
Correct.
Check for 20,000 rupees issued in this account by certified because in cash. Accidentally, I will see it from present. So that is the suspicion. But she has given one statement.
Should have gone to the bank for distributing wedding cards in the morning session. Then no problem at all. We went to the bank for distribution of wedding card in the wrong hours. Yes.
She has given one man.
82.
80 is her handwritten.
Yes.
82. I have been working in Vijayanagar branch since 2012. On 10th 2012, I was an officer. Check number 930112 dated for rupees 20,000 was received. Payment at the cash. Check was entered by the teller. Submitted to me for authorization. Was already signed and the reverse. Check was an order and signature of the card. According to check was passed. I also know the party who had Frank was when I was worker again before coming to this stage I go. I do not remember who has received the payment. One of the not
Anyways, you say that you are there.
invitation to me as well as I understand that the guy which is has confirmed this.
Yes.
Page number 74.
Yes.
Saraswati Government officer. Indicate 18 different statement dated 1-2-4.
Okay. So she deposited, she has confirmed it.
Come to next page.
Why you not participated in the proceedings? Why not participated in the proceedings? In the proceedings, inquiry proceedings.
So he had no means. He was staying around the side. And the inquiry was conducted somewhere census office. He had no money to answer. The amount was 600 rupees per month and 20 rupees per day.
Maybe.
20 rupees. He went to officer.
Yes.
The MWQ 75 is
Yes.
MW2.
Yes.
Investigation report submitted by me in connection with the fraudulent withdrawal of 5 lakh from CA company. Think of that kind of event. MBH2 MBH on the document. One. MBH28 is a complaint letter. Since yoga nursing, the next page is MW3. MW3.
Yes.
MW3 is from bottom third side.
Yes.
That's 76. Sri Yoga Narasimha has stated the sum that is stealing CA-1392 and this on behalf of he has stated that he has been victimized part of the MW3 and the respondent bank. MW4.
Yes.
The MW4 is already as a statement signing. Further, the respondent bank has given police complaint. As per page number
120. Right.
If you want to the subject that police,
What happened in criminal case?
correcting additional 5 lakh 50 for which he is not at all responsible. Police complaint, nothing has happened. Police also.
It was not here. He left. He left Bangalore and stayed at native. Now we will pursue. Now we will tell the police to take care of it. Now we will tell them to take action.
They have not taken this is how many things have happened.
Yes.
And they have issued issued by state government.
Where is that? Annexure T.
Again, this is also prepared by others.
Yes.
And this is signed by assistant general manager, not the disciplinary. Action is issued by this deputy general manager.
And your representation is in English.
Some Indian leader would have.
How can you say that you are not? That is there the point lies.
Yes. Since he is issued by deputy general manager. punishment is issued his subordinate.
Yes.
Still I am on the road. This is the punishment order is not. It's just action on the road.
Annexure T.
Then of course I have given a letter to the bank. Actually, we will not next. This is with reference to the above, I will make the period detail to the office.
Yes, next. So you approach the labor court also.
Labor court, yeah, labor court is. Fine.
Yes.
So I'm still on the road. It's giving the threatening. It's very clear that obviously you may be kind of target.
Yes.
But we can know the action and also yes.
You have participated in the inquiry. So you obeyed the oral orders. Yes, obeyed the oral orders. Next.
He has been demised because of his status.
Next.
No status.
Next.
So, difficult for 2 pages. So,
As a on par with the regular approvals. Yes. Yes, sir. Statement is filed, sir. Just when was the removal? Okay. Yes. Section R1. 1 minute. 1 minute. Statement. Yes. Annexure R2. 16. According to you, in terms of this circular, he has been appointed. What is the date of this annexure R1? 1984. Yes. Next is. Where are you reading? G, yes. Kind of H. Oh. So according to me, it's not a regular employee. Not a regular employee.
Then you are not able to talk to 3 days. And 3 days, what is that? Then we are.
Yes. Sorry. Yeah. Just pass on to one more. The faith when working with in the bank. Trust. You must trust. Report ಆಗಿರೋದು ಕೊಡ್ತೀನಿ. Report ಆಗಿರೋದು. I will take this. Para sir? Trust and confidence. That is a 2001-9 SEC. I got it. Yes. I got it. Yes. Yes. What do you say about delay? Delay. What is the material that? What is the material to show that the impugned order is served? Is forwarded to him? Is served to him? No, what were you doing from 2000 till? No, what were you doing from until 2000 till you leave? They asked you to go. Take for an example. But 2011, where were you doing? So 10 years. But no, what efforts that you made that you asked for these documents at least? This depaneling you.
There is no deeper system at all.
No, you should have. Just you leave everything on merits. 2010 order is passed. What were you doing till for 12 years?
2042.
What happened? When was the labor court disposed of? Where is that? Where is that? Where is that?
Page number
120. When it was issued? 22. When you approach the labor court? That's what I'm saying. What were you doing from 2010 to 21? Yes. Yes. Leaving out on merits. No, leaving out the merits. Told him. Directly. Directly. Please.
My dear friend is
I'm sorry. Not a case to interview. Nothing. For the different forum, not this. Not this forum, not this forum. I've seen it. Yes, sir. In this, please sit down. Please sit down. In this writ petition, petitioner has challenged order dated 21/12/2010 within bracket annexure P passed by the respondent bank, inter alia sought for a direction to the respondent bank to consider the petitioner as a regular employee in the sub-staff cadre from 1/10/2003 and such other consequential reliefs. It is the case of the petitioner that the petitioner was appointed as part-time employee in sub-staff cadre at SAI capital, SAI extension counter of Battarayanapura branch Bengaluru. As per letter dated 2010-2003, is further stated in the writ petition that the petitioner being eligible for full wages with consequential benefits and he is a party to the bipartite settlements as mentioned at Annexure D and E respectively, and accordingly sought for consideration of his case as a regular employee. The petitioner further averred that the respondent bank has issued charge sheet dated 8/7/2010, by an incompetent officer of the respondent bank, and conducted an inquiry contrary to Rule 16 of the settlement dated 10/4/2002, in a language not known to the petitioner, and concluded that the charges leveled against the petitioner has been proved as per where is that inquiry? As per the inquiry report produced at Annexure L. Is it L, sir? Inquiry report is Annexure L. Alla? Inquiry report as per Annexure L to the report. The petitioner has investigated. Inquiry report. A copy of the 7 days report. Findings. Findings. As per the inquiry report produced at Annexure Q. Annexure Q to the report. It is further stated that petitioner has not been intimated with regard to the impugned order passed by the respondent bank, and thereafter petitioner was constrained to approach the labor code as per Annexure Y. However, the conciliation process ended with no result. And as such, the petitioner has presented this writ petition seeking quashing the order dated 21/12/2010 within bracket annexure T was by the respondent bank. Respondent bank deleting the name of the petitioner from the panel of daily wages. I've heard Sri K.R. Ganesh Rao, Nana Council, appearing for the petitioner. And Sri T.P. Muttanna, Nana Council, appearing for the respondent bank. Sri Ganesh Rao, Nana Council, appearing for the petitioner. How you are, sorry, how you are communicating? Ganesh Rao, Nana Council, appearing for the petitioner. Just when, how you are communicated? How? Through post. Where is where is the postal? Sorry. So Ganesh Rao, Nana Council, appearing for the petitioner, contended that as per the letter dated 8/10/2003 issued by the respondent bank, a petitioner has been appointed as part-time employee on consolidated wages of 650 rupees 650 per month with working hours of 6 hours per week at the Sai Extension Counter, Canara Bank, Bengaluru. He further contended that in terms of the settlement, bipartite settlement, in terms of the bipartite settlement, as per class 21 of the same, the petitioner to be considered as a regular employee and not part-time employee of the respondent bank. Sri Ganesh Rao further contended that the respondent bank has issued charge sheet whereby same is issued by the DGM of the respondent bank and not a competent disciplinary authority. And therefore, the entire inquiry proceedings requires to be set aside. Okay, nextly, the entire proceedings have been conducted in English language which is unknown to the petitioner, and the petitioner was unable to understand the same. And therefore, the entire proceedings requires to be set aside. As same is contrary to clause 16 of the memorandum of settlement dated 10th April 2002 within bracket annexure G. Finally, Shri Ganesh Rao argued that the impugned order dated 21/12/2010 has been issued by an incompetent authority, has been issued by the Assistant General Manager, and same has not been served to the petitioner. Accordingly sought for interference of this. Per contra, Sri T.P. Muttannal and a counsel appearing for the petitioner invited the attention of the court to a circular dated 19/12/2004 and argued that the petitioner has been selected as a daily wager, and therefore cannot be considered as a regular employee of the respondent bank. He further contended that impugned order has been served to the petitioner and the petitioner has approached this court belatedly in the year 2022 and therefore sought for dismissal of the petitioner on the ground of delay and laches. He also taking through the court the evidence adduced before the inquiry officer and also submitted that though the petitioner is not being a regular employee of the respondent bank, the respondent bank has conducted disciplinary inquiry after affording opportunity of hearing to the petitioner, and therefore this court cannot interfere with the findings recorded by the inquiry officer. Lastly, Shri Muttanna submitted that the petitioner has approached the labor court, and as there was no settlement as reached before the conciliator, petitioner discontinued the conciliation and therefore argued that the petition deserves to be dismissed on the ground that the respondent bank has lost confidence with the petition. In the light of the submission made by the Lana Council appearing for the parties, On careful examination of the writ papers would indicate that petitioner has been appointed as part-time employee on consolidated wages. In bracket annexure A and B respectively. No document has been produced by the petitioner that he has been regularly recruited by following the procedure by following the requisite procedure, and therefore for all the purpose the petitioner to be considered as a part-time employee of the respondent bank. I've also noted the but A and B. I've seen. I also noted it. I have also noted. I've also noted the charges leveled against the petitioner, which would indicate that a withdrawal of rupees 5,50,000 in the current account of Mrs. Shanti Enterprises using 5 check leaves. And in this regard, the respondent bank having come to the conclusion that a misconduct has been made by the petitioner, has lodged a complaint to the jurisdictional police. As per annexure, which is that, sir? As per annexure, which is that complaint to the police? Annexure M, as per annexure M, on 23/2010. Though the argument of the counsel appearing for the petitioner that the charge sheet has been issued by the incompetent personnel and not the disciplinary authority. However, the said contention has not been taken during the inquiry proceedings, nor by raising such plea in the reply to the show cause notice or pursuant to the order passed by the disciplinary authority. And therefore, the said plea cannot be considered. It is also forthcoming that the order of appointment as part-time employee has been issued by the manager of the Bangalore Circle Office Batrayanpura branch and in terms of and the order the order deleting the name of the petition from the panel of daily wages was passed by the Assistant General Manager. And therefore, I do not find any merit in the submission made by the learner counsel appearing for the petition. Insofar as the contention raised by the petitioner relating to the language adopted during the inquiry, having noticed the reply dated 11/6/2010 within bracket annexure B, close the bracket, whereby the petitioner has signed the representation in English language, in English, and the contents are in the English language, and the perusal of the application produced at annexure C would indicate that the petitioner has studied up to 7th standard, and therefore I'm of view that as the petitioner has signed annexure B in English, which is in which the contents are in the English language, I'm of view that the petitioner is well aware about the English language, and therefore the said contention cannot be accepted. Finally, the petitioner has approached this court during 2022, challenging the order dated 21/12/2010 after a period of 12 years. It is the case of the petition that the petition was unaware about the order dated 21/12/2010, and if the said submission is accepted, what prevented the petitioner from approaching the bank for a period of 12 years in between is not forthcoming from the writ petition. And in that way of the matter, it is not the length of delay and the cause for delay plays vital role while considering the writ petitions under Article 226 of the Constitution. In view of the law declared by the Honorable Apex Court, Nagaland, in the case of Deepak, State of Nagaland versus Deepak, 2005, 2005 so and so, before the SEC, I do not find any infirmity in the order passed by the respondent bank. Accordingly, the writ petition deserves to be dismissed, even on the ground of delay and laches. Maybe that is open. They are only in so far as DE available. That's a different, not under 226. The result petition is rejected. Can pass agree.
So, I'm very familiar. But let me
Madam.
Huh?